discussion, and also now invite onto stage Peter Douglas Ling, who is also a member of the organizing committee for the Sports Arbitration Conference and also a partner at Peter Ling & Co., and who I myself know personally to be a very avid sportsman over various sports, and who will then kickstart this discussion. So please, I do look forward to this interactive session with the members of the audience as well. Peter, you can take it away.
Thanks, Lishi. Hello. I think I speak on behalf of the floor when I say that the two speeches were very informative, very enlightening. Thank you very much both to Paul Hayes and Richard Wee. Now, before we open up to questions to the floor, perhaps I will start with one question. Paul, you went through various procedures and processes of the KAS. There are murmurings of impartiality or lack of fairness, some decisions. Is there substance to that, really?
In broad terms, no. KAS is no different from any other curial court or arbitral tribunal where there's going to be people dissatisfied with the procedural fairness accorded to them in hearings from time to time. We wouldn't have the common law relating to the law of bias in court hearings before state courts in all common law jurisdictions, nor would we have cases dealing with the challenging and enforcement of arbitral awards in state courts in a variety of international commercial arbitration cases, and including KAS, also on the grounds of bias. So institutionally, I don't see any problem at all with KAS, and it's no different to any other institutional arbitral body or indeed any state court. There's always going to be concerns from time to time in any form of adjudication, be it curially or in arbitration, as to whether or not procedural fairness has been accorded, and KAS overall does a very good job in determining difficult disputes, often under a considerable amount of pressure of time.
Thanks, Paul.
You have to ask me.
Okay, Richard, you probably could answer this as well. You know, we're very lucky to be given a seat as a host of KAS. You know, Kuala Lumpur is very lucky to have that. So we're very proud to have this opportunity to be part of this global exercise. Besides low costs, what kind of advantages would KLIAW and Malaysia offer?
Thank you. I'm going to speak with my hand on my heart. So I would apologize if I sound a bit too passionate or emotional. But I think Malaysia has one of the better lawyers in this region. So we are ready in terms of the legal profession. We've seen many of our lawyers performing very well in international arbitration. So I think in terms of the bar, we are ready to serve the clients for KAS. So we are ready. Perhaps, you know, all of us, we need to pick up new, for example, now we have the new SIPA Act. It took time for us to learn. We are learning it. We got it. We are moving with it. So I think if Malaysian lawyers are given the correct or fair amount of, reasonable amount of paper or literature for law, we're okay. In terms of infrastructure, KLRCA, I mean, just look at the building. I think the building itself is Rebsa Lokito. It speaks for itself. We are ready. We have a fantastic amount of rooms, the amount of access. We are near KL Central. If we have a foreign, non-Malaysian visitor, one flight, one train, we're here. In terms of access to knowledge, we have the University Malaya Library is just down the road. So in terms of infrastructure, we are ready. If you look at OCM and you look at our sports association, we have many Malaysians who serve this association on voluntary basis. So these are people who do it out of love because they really want sports to succeed. So when people do things with their heart, though things may get emotional sometimes, but they get it done. And that's why I think CAS coming to Malaysia is not just accurate, but is a correct decision they made to come to Malaysia. So like I said, I'm sorry if I sound too nationalistic, but I'm just very proud of our country. I also feel that not only will we be able to take it, and let's be honest, it will take some time for us to understand CAS. It's what Paul just gave us for 1 hour can be lectured in 6 months, 8 months. That's how deep this topic is. So we will take time to learn. But once we get the topic and we are ready, I not only think we will serve well, we will lead. And I'm hoping personally, that's why we are doing this conference. I want Malaysia to be the regional leader in the Southeast Asian region, to be the leader for sports arbitration. We can do it. We have the intellectual capacity, the physical capacity, the infrastructure to get everything done. So yes, Peter, the answer, long story short, answer is yes.
Paul, have you got anything to add to that? What does Malaysia and KLIAW have to offer above its competitors, obviously?
I adopt the submissions made on behalf of Malaysia by Counsel for Malaysia, Mr. Richard Wee, in their entirety. But look, Richard's absolutely right. There's an enthusiasm for international commercial arbitration here, which is apparent, not just from the building, but from, in recent years, the enormous number of Malaysian people active in international commercial arbitration in the region. And that's really impressive to see that. Secondly, there's a real interest in sport in this country, and certainly in sports arbitration, which is refreshing. So those two things combined together lead plainly to my third point in agreement, and that's the fact that with the very early steps relating to MSAT, and it's very early days, but the Olympic Committee of Malaysia has shown a considerable degree of initiative in going down this path, and in what I hope will be next year, we'll be here hopefully, or in time, and these things take time, but at the appropriate time, lauding the establishment of MSAT. That will squarely position Malaysia as a regional leader in sports arbitration, and by that I mean in the Asian Pacific region. That not just doesn't include Southeast Asia, that includes Australia, New Zealand, and go all the way around the Pacific Rim, United States, Canada, Japan, and the like. So those three things combined, I think there's going to be a very, very good story to be told about Malaysian arbitration generally, but more specifically Malaysian sports arbitration in the years ahead.
Thanks, Paul. We'll open up now to the floor. Any questions that you have for either panelists? Everyone's hungry, but yes.
The mic is coming.
I have a question arising from one of the slides. It was mentioned that rules must be clear and predictable and understood by the entire community, be informed of the normative system in which they live, work, and compete. Now, there may be rules understood by all the participants, but not cast in writing. Would that be enforceable actually against a player?
Sorry, not in writing.
Not in writing, but understood by all the participants in that sport.
It's a good question. It depends on the rules. Sport and it depends on the sport. Sometimes many rules are observed in the breach. If one wants to drill down and look at various types of rules, I'm not terribly familiar with soccer, but it wasn't my sport. I was a rugby player. But one of the things about committing fouls on other players seems to be, on my cursory understanding of the game, seems to be somewhat differently applied between different as to what constitutes a foul on one player and what doesn't. And so things like that, not everything, the rules will be the same, but it's how they're interpreted and applied that differ. Now, that would be an on-field dispute, so you're never ever going to finish up in court on something like that, unless, of course, it involves a suspension and the like. And if that were the case, I imagine, it's really more an illusory or an academic distinction that you make. But by and large, what Quigley was about, it was a doping case. And so, especially in things that have a material effect on your participation in sport as an athlete, or from an organisation's point of view, that govern the participation of people in sport and upholding the premise of clean sport, it's very important for those rules to be clear. Because while the WADA Code is a body of regulation which gets worked on every 6 years, there's a new version of it, and a lot of lawyers put their heads together and try to make this regulation as specific as possible, as we've seen with the provisions relating to unintentional doping in Articles 10.4 and 10.5 of the World Anti-Doping Code, there's always room for interpretation. And that's where CAS plays a role, because CAS brings about the clarity that where the ambiguity might be in the rules that's lacking from time to time. And that's, again, why it's important that CAS awards are public, so that any ambiguity in the rules is ultimately clarified. So I hope that answers your question. Thank you.
Any other questions? From? Sorry.
Distinction and the limits on a person appearing as an arbitrator as well as counsel. That's something that exists in CAS arbitrations but not in commercial arbitrations. Looking at the needs of the domestic market here in Malaysia and moving forward with MSAT,
that's a really good point.
Is that something that would be...
other than Islamic banking and Islamic finance scene,
we seem to have captured the voice from the other hall.
I thought someone was saying that was a good point.
That sounds like Mali Imtiaz.
Anyway, my question is whether that same limit would be appropriate looking at the Malaysian needs and MSAT moving forward.
Yes.
Can I ask the CTR? He shouldn't be in sports. He should be in the... Okay.
Yes, Faris. Obviously, in the context of MSAT, it's an important thing for you and I to consider, I think, when we fine-tune the draft rules in the weeks ahead. But yes, obviously I'd be interested in Tunku's views on this, but...
Actually, in my virtually last meeting on the ICLAS, this very issue was discussed, and I think it was very clear that a directive went out to all the arbitrators and to say, are you going to be a counsel or are you going to be an arbitrator? It's very clear. They could, but they couldn't take both roles.
My personal view is that's the right thing, and that's CAS policy. In the CAS jurisdiction, you have to make up your mind whether you're going to be an arbitrator or counsel.
Ultimately, what's the benefit
my
of bringing forward
preliminary thoughts
if ultimately the arbitrator
are
court
that
has to...
in MSAT, our position should reflect the position of CAS and should be consistent with CAS, given that ultimately, if you look at the way in which cases will flow, with limited right to appeal and right to appeal will ultimately finish up before CAS. So the more consistent we are with MSAT and CAS, I think the better. And especially on that point, that's a very good point you raised, Faris.
I think we'll open it up to one last question, if there's any. Yes, please.
Hello, hi. My name is Clinton. I've got a question for Paul. I hope to benefit from, like you say, you having grown up with the whole sports arbitration scene. So my question is this. Correct me if I'm wrong. I understood your slides to say that the burden of proof in sports arbitration is, what do you call this? Comfortable satisfaction.
Comfortable satisfaction.
Which is in between your criminal beyond reasonable doubt and your higher than your bands of probability. So if I've understood that correctly, then my question will be this: why the need to increase it from your civil burden? Because essentially, if sports arbitration is a breach of rules and regulations, so it's a civil breach of contract, essentially, why the need to increase it to, in a way, a quasi-criminal kind of thing?
Thank you for the question. And it's a very good question. How it came about in the Mark French case, which was a doping case, a non-analytical positive case. So this is a case where a person hadn't delivered a positive test, but was found to have committed an anti-doping rule violation by being allegedly in possession of drug injection paraphernalia in a room that he once occupied at the Australian Institute of Sport. So, do you remember in the course of my address talking about public, private, domestic, international, and the skills of a commercial lawyer with a contract, and yet in running some of these cases, then when it comes to dealing with the evidence, you're putting on a hat or a wig similar to that of a criminal lawyer or a common lawyer. This was such a case. Now, let's retreat from that for a moment. The very idea there are three sources for this rule. Firstly, it talks about comfortable satisfaction specifically in the World Anti-Doping Code now, in the current version. Secondly, in 2003, the case of was it Cabeva, and in fact it was Cabeva and the FIG and Dos Santos and the National Olympic Committee of Brazil dealt with this very proposition, trying to define what comfortable satisfaction meant. We had the benefit of the efforts of CAS panels in Cabeva and Dos Santos when we argued French. And in Australia, the High Court, in the case of Brigginshaw and Brigginshaw, which is 1934 CLR, deals with the issue of comfortable satisfaction, which often arises out of civil cases and is invariably applied in matters concerning disciplinary tribunals, which is authority for the proposition, where the more serious of the nature of the allegation, the more comfortably satisfied a court ought to be as to its proof. So it's all very well to have a civil standard of proof, but if you're making a serious allegation against someone, and one could not consider, there's not too many things that are more serious in sport than calling someone a drug cheat. That's, it's a pretty serious allegation. Then you're not going to want to make that sort of finding lightly, hence the need to be comfortably satisfied. Now, yes, it isn't a criminal proceeding, so plainly it's not beyond reasonable doubt. But you're not going to make that finding lightly, so you're going to want a little bit more than whether the scales, having evaluated the evidence and informed yourself of the law and weighed the evidence against the legal thresholds, you're going to want a little bit more than the scales tipping slightly to one side. You want them to tip a reasonable degree to one side in favour of the proof of the offence. So it requires the adjudicator or the arbitrators to be so comfortably satisfied, and that's the juridical basis of that standard of proof, and hopefully that's addressed your query, but it's a very good question.
I thank you for that. I think, yes, I understand the rationale. Yes, there's a lot of sense and value.
I thought that was Clinton thanking the panelists.
Yeah, I accept that. And
it's coming
from the other hall. So you see, KLRCA is so powerful that you can hear two lectures at one go. The infrastructure is so good. Yeah.
They're probably learning something in arbitration.
Clinton looks like he has another question.
Sorry about that. I just have a very quick follow-up. Does that mean that the comfortable satisfaction test applies across the board? So I can understand what you mean when it comes to doping allegations being serious, but what if it's about, for example, a dispute on nationality? So that perhaps just comes down to a plain reading of the law. It's all pedantic. There's no criminal allegation in it. Does the higher threshold still apply then?
Well, the whole idea of comfortable satisfaction is it's not meant to be specific. It has to be on a case-by-case basis. I would cavil with you to some degree to say that eligibility cases, presumably that's what you're referring to when you talk about nationality, are not that important. I would disagree, because ultimately there is an individual's right at stake to participate in an Olympic Games, and where these issues invariably come up is where there's a limited field. Say, for instance, there's only 24 people who are going to participate, or say 16 teams in a teams event that go through the pre-qualifying tournaments, or competitors. And
given an option now,
a person is placed 17th, and they've just missed out, and this is generally how eligibility cases come to light. So it's generally the 17th placed person who thinks, hang on, in that 16, competitor X, how can they possibly represent Bulgaria? They've been living there for 5 minutes, and it just doesn't meet the nationality requirements under the International Federation or under the Olympic Charter. So I'm going to challenge that competitor, because that's wrong. They've just moved countries so that they can get to the Olympics. I should be at the Olympics. And invariably what will happen is that individual will be backed by their own, the 17th place athlete, by their own National Olympic Committee, because that National Olympic Committee will want their athlete to be in the 16 competitors rather than the one who offends the eligibility requirements. So it's important not just to the 17th placed athlete, but also to the National Olympic Committee and the local sports council that's invested resources in developing that athlete. So there's a little, I'd respectfully suggest there's a little more at stake, but sure, not as serious as a doping offence, hence the need for some relativity and flexibility in the comfortable satisfaction test.
Peter, would you mind if I try to...
Yes, go ahead, Richard.
You know, Clinton, I'll echo Paul at one point. Paul said something very key. It's a case-to-case basis. In most cases involving sports dispute, every case, as you just heard from both speakers, there is no judicial precedent. Every time a case comes before a tribunal, either a football disciplinary committee tribunal or a specialized tribunal to decide whether an athlete is recalcitrant, that tribunal will hear the facts for the first time, listen to this case on its own, and can't really compare with another case which happened 7 months ago, because the facts may be different. So that is why fundamentally all sports dispute cases are case-by-case basis. And the moment you have a case-by-case basis system, you don't need a beyond reasonable doubt or a balance of probability test, because that is for purposes of uniformity, conformity, making sure Judge A will follow Judge B. We don't have that. And all we need is the person who decides must be personally satisfied. So that's why even in commercial cases involving contract disputes for sports, they have an arbitration clause. The arbitrator must be personally satisfied that A breached the contract against B. Doesn't matter whether a similar contract happened 6 years ago with another 2 athletes. They don't have to follow that. Persuasive, but don't have to follow. So on that logic, that's how we apply it. I mean, that's how I personally apply when I do the cases. So does it help? Yeah, thank you. Okay, at least I spoke louder than Malim just. Yeah. Any other questions? Because it's Friday and
yeah. I think because it's lunchtime now and it's Friday, we'll close off all further questions. I think it would be right for me to ask the floor to give a warm round of applause to our 2 distinguished speakers. Thank you very much.